This program is brought to you by McGill University. Please visit us at www.mcgill.ca.
Tina Piper is assistant professor here at the Faculty of Law, and she is a member of McGill's Center for Intellectual Property Policy. She has taught intellectual property law, Canadian legal history, and also an interdisciplinary course on new models for music creation and distribution. Professor Piper graduated from the University of Toronto Engineering Science Program as a national scholar with a specialization in electrical and biomedical engineering. She then graduated as the gold medalist at Dalhousie Law School in 2001. Professor Piper researches why people create and innovate in science and the arts, and how we can better encourage and disseminate their works. She explored this from different angles, starting from intellectual property law and including insights from history, empirical studies, and from other academic disciplines. She is particularly interested in distributed collaboration, open networks, and novel legal approaches to intellectual property. Her research is both theoretical and applied. She is involved in pro bono advocacy, research and support for NGOs, and advises governments and international organizations on innovation strategies. Ladies and gentlemen, Professor Tina Piper.
Thanks very much. Okay, so today we're going to be talking about intellectual property law. And as I develop the topic, it'll become clear to you why I put this byline, you don't have to be an intellectual to need it. But that won't be obvious at first. So to start off with, we need to understand what an intellectual property right is. I like to summarize it by saying it's not actually a right to do anything. It's actually just a right to stop someone else from doing something with your thing. So it's basically a right to exclude someone from using your creative work, using, reproducing. The various statutes that define intellectual property rights define a whole series of things you can't do with the creative works that are protected by intellectual property law. I want to situate what I'm going to be talking to you about today in the world of intellectual property law. There are three types, traditionally, of intellectual property rights. The first is trademark, second is patent, and the third is copyright. And you might actually recognize them. The little TM you've probably seen before on brands. The little C you've probably seen before on written works or novels that you might have bought. And patents, not so easily identifiable, but with us everywhere, including this presentation. So, and today I'm going to be focusing on copyright, but I would be remiss if I didn't situate it for you in the bigger world of intellectual property rights. And I thought the easiest, fastest way of doing this would be to give you an example that you're all familiar with, that you all have access to, and that's a recipe. So we're going to talk about a recipe as a type of intellectual property right. So this is a recipe I found online for perfect vanilla ice cream. It promises to be perfect, so I thought, okay, this will be the kind of ice cream that we all want to make. And it involves combining a number of ingredients, so light cream, sugar, a teaspoon salt, a quarter teaspoon of salt, 4 egg yolks, 2 teaspoons of vanilla, 2 cups of heavy cream. I've synthesized the instructions. The last time I made ice cream, I was in grade 2. So it can't be that hard, but essentially it involves some sort of heating and then some sort of freezing of the ingredients, and then of course you get to eat it. And so we can all agree in this room, I think, that the ingredients for making ice cream are in fact well known and common. Nobody can own this information. I can't ever claim to own the recipe for vanilla ice cream, right? You'd object to that if I told you that I owned this recipe, right? Yeah, it's basic information. So what does intellectual property do? Well, intellectual property carves up the segment of this recipe into various different parts. So you may be familiar with Ben & Jerry's. That's the association of the mark Ben & Jerry's with a certain type of ice cream that tastes a certain way. So when you buy vanilla ice cream from Ben & Jerry's, it tastes a certain way. And you associate that with the Ben & Jerry's brand, and you might associate certain things with the Ben & Jerry's brand. For example, you might think that it's good ice cream, for example. And so you tend to buy ice cream that's labeled with that kind of a mark. So that's trademark. Now, can you even guess what this is? This, anyone? It's a recipe for making ice cream using liquid nitrogen. So we have all our basic ingredients here. We have the eggs, the cream, the strawberries. That was absent from the perfect ice cream, but nonetheless a pretty good ingredient. We have the liquid nitrogen, I believe. I believe that's the liquid nitrogen over there. And so the idea of making ice cream, instead of making it on the stove, for example, but making ice cream by using liquid nitrogen instead of using a freezer or using standard kitchen utensils, is sort of innovative. And in fact, you might actually apply for a patent over that idea, the idea of using liquid nitrogen to make ice cream. That would be a patentable invention. Now, making ice cream in the standard way is obvious, and we don't allow patents over obvious inventions. But we allow patents over particularly innovative things. And making ice cream out of liquid nitrogen seems to be pretty innovative. In fact, I did a search of the US Patent and Trademark Office database before I came here, and there is a patent granted to a Mr. Inagaki, patent 4,993,238, that covers manufacturing methods for making ice cream with liquid nitrogen. So yes, there is actually a patent, a US patent over making ice cream with liquid nitrogen. So keep in mind what is patentable, what in fact is covered by the intellectual property right. Not the basic facts, not the fact of making ice cream, not the ingredients to make ice cream, but the idea of making ice cream in a different way. So we've covered trademark and patent, but what is copyright? Well, copyright covers the expression of ideas, but not the ideas themselves. So the idea of making ice cream, the basic ingredients for ice cream, that's an idea. We all accept that these are the basic ingredients for ice cream. We make them in a certain way. But expressing that recipe in a novel way is in fact the creative work that the Copyright Act protects. And so rewriting this recipe and adding this sort of red hatching, putting a picture of ice cream, writing your name in fancy script. I found this on the internet. Putting a little copyright symbol in the corner here that you can't probably see at this moment. This recipe, this picture, is copyrightable, but none of the ingredients is covered by copyright. The idea of making ice cream isn't covered by copyright. The only thing that Heather Bailey could stop you from doing is in fact reproducing this particular recipe and giving it as a copy to your friends, but she wouldn't be able to stop you from making ice cream. No, she wouldn't. So that's basically what trademark, patent, and copyright law protect. And what I'm going to be talking to you about today is copyright law. And I'm going to be talking to you about this basic distinction between ideas and their expression. I'm going to be talking to you about the distinction between facts and the kind of things that copyright law is there to protect. And I'm also going to talk to you a bit about why we have copyright law. And the basic idea behind copyright law is this principle that we want to encourage people to create things of value, creative works like this recipe, and we do it by giving them an exclusive right. We give them the right to stop other people from, for example, copying this recipe and giving it to other people. And we do that through law. And we do that through written laws. But I also like to think about unwritten laws. And so I'd invite you all, as I proceed through this discussion and afterwards in the question and answer session, to think about all those ways that you share creative works, you share information, you share your expressions with other people in ways that aren't regulated by law. And so it's really interesting because chefs, for example, share information amongst themselves, and they don't use intellectual property law, they don't use copyright, they don't use patent or trademark. They rely on principles or norms that govern their group. When you think about, in the university, we think about plagiarism, for example. Plagiarism isn't covered, it's not a copyright violation. I mean, it can be in some instances, but we enforce it as an ethical norm. We enforce it as an ethical problem. We object to the idea of someone copying someone else's work, but it's not a legal problem. And so what I'm going to be talking to you today, is the world of written laws that prevent the exchange of these types of creative works. And the basic rules about copyright law are set out in the Copyright Act. The Copyright Act is a Canadian statute. It sets out the basic rules and procedures for copyright law in Canada. Has any of you ever encountered a copyright problem? Yeah? What kind of copyright problem?
Neighboring rights. Music.
Neighboring rights, yeah? And you?
The New York Times trying to sell one of my copyrighted pictures.
Oh, interesting. New York Times trying to sell one of his copyrighted pictures. So copyright touches us all, and that's in part why I thought it was a valuable area of intellectual property law for us to discuss, because every day each of us creates a copyrighted work, likely, if you're involved in writing. And also each of us every day likely violates one or several intellectual property rights, someone else's copyrights. And this has become increasingly prevalent as more and more works enter the internet, and as every work on the internet becomes a reproduction, copyright violations magnify. And so part of what I want to talk to you about today is the boundaries of intellectual property law, not so much what copyright covers, but also what it doesn't cover, so that we can understand what kind of activities we should be wary of, and then what kind of activities that we can freely engage in. Because copyright's so prevalent, it's sometimes hard to tell where it ends. And part of my discussion today is going to be about where it in fact ends. So just to recap, it's a right to exclude anyone else from using and reproducing your work. A work is defined for the purposes of the Act as a musical, literary, dramatic, artistic work. There's a whole list of different types of works. I've highlighted the important ones here for you. And in order to protect that work, it has to be original. So copyright law only protects original works. It doesn't protect unoriginal works. But then you're left to wonder, well, what is original? We spend a lot of time with my students, for example, asking them to produce original work. But what is originality, and who gets to decide? It's a very subjective judgment. What may be original to one person might not be original to someone else. And so the court spent a lot of time thinking about what merits copyright protection. And in part, that's because we only want to grant copyright to the kind of works that deserve protection, because those works exit the public domain once they're protected by copyright. They don't become available to everyone. And so we have to think carefully about the kind of works that we want to encourage through copyright law and the kind of works that we want to attach copyrights to. And the starting point in Canada that I'd like to start from is the 2004 decision of the Supreme Court of Canada called CCH Canadian and the Law Society of Upper Canada. And the actual copyrighted works in issue in that case weren't they weren't as exciting as some of the works that are the subject of copyright cases, but it was cases reported by judges. So I don't know if any of you has ever seen a reported judgment from a court. It is basically a statement of the facts, the issues, and then the decision that the judge has reached. to us, to those of us who teach and practice law, it's essential that we be able to access these types of judgments so we can understand what the law in fact says. Industries have developed around collecting these judgments, editing them, and then adding summaries or headnotes to those particular decisions. And so those decisions become more accessible because the principles of law are summarized at the top. And the CCH, Canadian Law Society of Upper Canada case, which I'll call CCH from now on, was about whether those decisions with the summaries on top were sufficiently original to merit copyright. I mean, it was a case about a lot of different things. And we'll cycle back to it at the end of the presentation because it really spoke to the strength or the extent of copyright in Canada. And it has a lot of lessons for us when we think about what copyright actually means. But the basic decision was, around originality was, is a summary of a decision sufficiently original to merit copyright protection? And the court effectively said yes. I don't know if that jives with your instincts. Is a summary sufficiently original to be protected by copyright? Well, the court said it actually takes a fair bit of skill to summarize something. You have to understand what's important and what's not important. And so a bad summary is one that's going to say too much, and a good summary is going to be one that picks out the key details. And so the court came up with this principle that said originality means skill and judgment. But, interestingly enough, originality doesn't necessarily mean creative. So a summary isn't terribly creative, but it actually takes a fair bit of skill and judgment to produce. And so in CCH, the court set out the standard for what an original judgment will actually constitute. And in fact, an original work for the purposes of copyright law is one that takes skill and judgment to produce, but that isn't terribly original, that isn't terribly creative. So the question I have for you now is, what about your notes? If you're taking notes on this presentation, are they original? Are they copyright protected? How many of you think yes? Show your hands. Okay, so 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So about 12 people think that they're copyright protected. Okay. And those of you who don't? Okay, so we don't have too many people sitting out on this vote. Okay. Well, the consensus, I mean, it's a troubled issue, right? If you're reproducing verbatim everything I say, you're writing very quickly, if you're effectively transcribing what I'm saying, then perhaps it might not be sufficiently original. But if you're exercising some sort of skill and judgment in condensing and integrating what I'm saying, then maybe it is sufficiently creative, maybe it is sufficiently original, maybe you're exercising sufficient skill and judgment, even though maybe it's not terribly creative, to constitute copyright protected material. And that's where the law sort of unfolds on this issue. It's unclear. I might have an interest even. If you chose to post your notes of this presentation online, you might want to ask my permission. But you might not if you felt that you had sufficiently adapted the work, that you'd integrated it into your understanding of what copyright law in fact was. But we don't really have a clear answer. I wouldn't get mad if you posted it on the internet. I really wouldn't. I believe in sharing these things. So just in case you were wondering. But there is this question, is it a sufficient exercise of skill and judgment? And presumably if you integrated the PowerPoint slides as part of that note-taking experience, maybe it would be less original for the purposes of copyright law. In judging originality, we also come down to these complicated aesthetic questions. So because originality doesn't encompass a creativity standard, it's left to judges to decide what constitutes a sufficiently original work. And a lot of people have voiced some concerns about, resting the decision of what constitutes original artistic work in the hands of judges. They've mostly worked with the law. They might go to the theater every now and then, but they're not artists themselves. It's hard to, the argument goes, how can they appreciate cutting-edge art? How can they appreciate avant-garde art? How can they appreciate modern art? These sorts of things, and that's up for discussion. And so the governing standard is that it doesn't matter whether work is good or bad art. It just has to be some sort of art. And so copyright law is rife with the kinds of works that you might question as to whether they're good or bad. And you might actually think that they're bad art, but they are protected. So, for example, is Marcel Duchamp's urinal from 1917, is that copyright protected? Is an image of that copyright protectable? Is The Physical Impossibility of Death in the Mind of Someone Living by Damien Hirst from 1991, is an image of that sufficiently protectable as a copyrighted image? It's a shark suspended in formaldehyde. Is that good or bad art? Is that original? A lot of people have been debating this in the UK. Is this sufficiently original to constitute art, not much less original for the purposes of copyright law? So now we have a pop quiz to see how much, how your instincts are developing. So give me a sense of whether you think your diary would be copyright protected. Who says yes? Yes? Okay, good. Great. A list of phone numbers of your closest friends. It tends not to be. I mean, you might think, you know, there's an exercise of skill and judgment because, you know, you've picked your friends who you like. So you could argue that possibly it's copyright protected. On the other hand, it is a very utilitarian list. It's a list of numbers. And if you list it alphabetically, if that's the arrangement, then potentially not. So one might ask questions about that. You might ask the circumstances when you'd ask for that to be copyrighted. Because part of the context of intellectual property law is eventually you're trying to protect that from someone. So maybe someone stole your list of phone numbers. Maybe that's what you're concerned about. You have to think about the kinds of disputes that arise, because so many things are copyrighted in the world that it's almost daunting to think about them all. But the only time it ever really becomes a problem is if somebody violates your copyright. Copyright isn't a criminal offense, at least largely in Canada, it's not a criminal offense, so you don't have the state stepping in to prosecute people for copyright infringement. It's a civil offense, which means somebody who holds the right enforces it against someone who's violated that right. A video of your children playing, a home video, copyrightable? Yeah, tends to be. Skill and judgment in filming. Your efforts at making pottery in that class you took. I would say yes. My sense is that even though you might not be terribly creative, we don't have a creativity standard. Depends how many pottery classes you took and whether your pottery looks like a lump or whether it looks like pottery. That might decide the matter. But you know, assuming it looked something like a vase or a pot. Instructions you wrote for your sister on how to build an IKEA chair that you found difficult to assemble? Yeah, probably. The set of instructions might not be, although there have been decisions in the jurisprudence that have found that something as utilitarian as a brochure, a set of instructions, is in fact copyrightable. But it again would depend on the level of skill and judgment that one would exercise in making that. Originality also does not mean hard work. So it doesn't mean you've spent a lot of time assembling facts and figures. So the classic cases that arise are, you know, for example, our bus schedules copyrightable, our timetables copyrightable, our phone books copyrightable, our collections that people have spent a lot of time collecting basic facts for, are those copyrightable? And the justification around not rewarding mere hard work is a really serious one. And it basically says you can't get a copyright. The state's not going to protect your right just because you've been really good at collecting facts that should be accessible to us all. In fact, the state's only going to protect those sorts of things that require some sort of skill and judgment, where you've added some sort of creative value, because you don't want people monopolizing things like phone books or basic information about the weather. You want that stuff to remain in the public domain. You don't want that to be captured. And that goes down to this idea of the expression versus idea dichotomy. The idea that expression is protected, but a basic idea isn't. An idea may be synonymous with fact. So, another pop quiz. The character of the soup Nazi, is that idea or expression in Seinfeld? I don't know if anybody watches Seinfeld. is the character of the soup Nazi, because characters can be copyrighted. Is that copyrightable? Yeah, actually, it probably is. The law around characters is such that the character has to be sufficiently defined that it's not merely an idea. So the idea of a boyfriend wouldn't be, but the idea of a soup Nazi is fairly well defined. The title Hard Times. Probably not. It may not be sufficiently distinct. It may colonize too much. It might be hard. One of the rules of thumb is you don't want to allow an intellectual property right over something that someone else might want that has actually been in sort of common cultural currency for a long time. So a phrase like hard times, one that people might actually use in conversation, might not be. The plot of a story about a couple in love defying their parental objections to their relationship. No? I mean, one of the biggest cases in copyright law was about this very question. Two plays that had been put on, and they were both about kids who defied the odds to fall in love and cross-religious and other objections to have children. And the court held that no, in fact, it wasn't copyrightable, the idea of this kind of story. What about Ashwinder? I'll show you what Ashwinder is. Harry Potter, the Harry Potter Bestiary, this encyclopedia of facts from Harry Potter. It was assembled by a fan, describing, basically an encyclopedia of the facts that show up in the Harry Potter novels, describing what in fact these terms mean. Is the term Ashwinder copyrightable? Yeah, so the courts have held that in fact facts are not copyrightable, but fictional facts are, which is interesting, right? So if you make up a fact, you're not taking it away from anyone, you're actually contributing something, and that's the kind of work that copyright law wants to encourage. One of the arguments is that copyright law wants to encourage us to develop our vocabularies and think of imaginary animals. So another important thing about copyright law is that the work must be fixed. So it's important to actually have something. If the dispute goes to court or otherwise, you actually want to be able to debate something. You want to have something to show. I'm going to talk to you a bit about the kinds of works that are protected by copyright. One of the most interesting for my mind is that we tend to think about copyright in terms of what is copyrightable, in terms of a corpus of a thing. But copyright's as much about what exists as what doesn't exist. And one of the most notorious cases of copyright protection was 4 minutes and 33 seconds, composed by a guy called John Cage, an avant-garde composer. Those of you who are at all familiar with this will realize that the reason why it's silent is because his piece was 4 minutes and 33 seconds of silence. And so the actual piece was musicians had to come on stage, they sat with their instruments for 4 minutes and 33 seconds of silence, and then they left the stage. And the idea behind the piece was to show that we're actually surrounded by noise all the time. There's ambient noise, that noise exists as much in the creation of noise as it does in the absence. But we don't call that noise. And so Cage's piece was challenging for copyright law. And in fact, his estate sued someone in 2000, well, threatened to sue someone in 2000 for creating a piece with 1 minute of silence in it. So what do you do with that, right? Where's the idea and where's the expression? There's no expression as we understand it, but John Cage, I'm told by my colleagues in music, one of the most famous avant-garde composers, considered this to be his most significant work. So he was inspired by another work that's difficult to classify for copyright law, The White Paintings by Robert Rauschenberg. White. Is that a work? Is that an artistic work? Again, that's a question we asked earlier. One of the questions that often comes up in copyright law is, do you actually need to label your work? And the really important thing to realize about copyright law is that copyright is automatic. So you don't actually need to label your work with the C, you don't need to register it, you don't need to do anything. You can register it if you want. The Canadian Intellectual Property Office, in fact, allows you to do that, but you don't have to. And the term of protection for copyright is the life of the author plus 50 years. Now, how did we come up with this number? Meh. I mean, it evolved. It evolved this way. It's not actually based on any sort of studies that have shown that after the life of the author plus 50 years, a work all of a sudden, doesn't become profitable to an author, for example. I mean, some works we can imagine have become more profitable. But once copyright expires, the work enters the public domain. And what does it mean when it enters the public domain? No copyright. It's freely accessible to all. So, famous Canadian example, Anne of Green Gables, by Lucy Maud Montgomery, 100 Years of Anne. Although this is a fascinating case, right, because the image of Anne has subsequently been trademarked, and all sorts of representations of Anne and subsequent reeditions of her book have also been copyrighted. So a book may enter the public domain, but a subsequent reedition with illustrations, annotations, and other information might not actually be in the public domain. This is how you determine whether something's entered the public domain. And one of the questions I always ask is, if it's so complicated to figure out if something's entered the public domain, and it's complicated because public domain changes based on when you published your work and a whole series of other factors, if it's so complicated to figure out whether something's entered the public domain, is the public domain working? And if you can take something out of the public domain by reissuing editions, for example, is that effective as well? And so as a result, I'm actually part of a project that's developing here in Canada for the first time anywhere in the world, a registry of materials in Canada that have entered the public domain. And what this seeks to do, it's actually pretty funny. To determine this registry of works that may enter the public domain is to provide a prediction date, because often with public domain, you can't actually tell with any certainty when the work's going to enter the public domain because there are so many factors that might affect it. And so there are a series of assumptions that you can make, assuming that the current year is 2008, that the year of publication was 1979, that the list of authors is complete, and that the author will live to age 117, the same as the oldest person ever in Canada so far. And so those are the kind of assumptions you have to make when you're trying to determine whether a work has entered the public domain, which is life of the author plus 50 years. And so the idea behind the public domain is to reinvigorate the copyright bargain, so to speak. It's to say, well, you've been granted this right for life plus 50, but then once that time is up, that work re-enters the public. Okay, so we've talked about what qualifies for copyright protection, and you can see it's a moving target. But basically, skill and judgment, but not hard work. And so once we've decided that something merits copyright protection, then we have to ask the critical question, well, has someone in fact copied it? What constitutes a copy of that work? Because copying is what the law prohibits. The law doesn't, I mean, the law regulates what constitutes creative work, but the problems come up when you start copying. And that's what CCH was about. CCH was about the Law Society of Upper Canada that had photocopiers, and the librarians were photocopying cases, these legal decisions, and their head notes for out-of-town lawyers. Up to 20% of the lawyers who used the service were out of town. They didn't have access to the commercial databases. They didn't have access to the library, for example. And so the library in Toronto was copying cases to send to these lawyers. And the publishers objected. They felt that the Great Library in Toronto was in fact infringing copyright. And it's an interesting ground in this case. They felt that the Great Library was violating copyright because it was authorizing copyright infringement. And they were authorizing copyright infringement by providing photocopiers where people were allowed to copy works. And so the core question of the case was, is providing a photocopier authorizing copyright infringement? So if the library has a photocopier, is that authorizing copyright infringement if you go and copy works? Not have works actually been copied on the photocopier that infringe copyright, but is it merely authorizing copyright infringement? What do you think? What's the general consensus? Is that authorizing copyright infringement to provide a photocopier? No. No, it's good. And this is why the common law makes sense, because the court agrees with you. The court said providing a photocopier doesn't mean that you're actually authorizing illegal conduct. We have to assume that when you provide a photocopier, that people aren't going to act illegally, absent any proof to the contrary. And they weren't given proof to the contrary. They weren't given proof that, in fact, people were using these copiers to copy judgments that infringe copyright. The other kinds of things you can prevent other people. So remember I said it was a right to exclude people from your creative works. Well, these are the ways you can exclude them. You can exclude them from producing or reproducing your work. You can exclude them from performing your work in public. You can exclude them from publishing, distributing, and translating your work. You can exclude them from adapting it into a movie. And you can exclude them from communicating it to the public by telecommunications means. And so the Supreme Court of Canada also had an opportunity to voice its opinion on what constitutes a copy. Claude Théberge, an artist maybe known to some of you from Quebec, created this piece, Celebration. And he'd authorized distributors to create posters and postcards and smaller versions of his work, and also larger versions. And an entrepreneurial gallery used a method of transferring ink. They removed the ink from the piece of paper, a sort of commercial grade poster, and transferred it to a canvas. And so all of a sudden, Claude Théberge's mass-produced works started to look more like gallery pieces because they were mounted on canvas. But the interesting part of the problem was that the gallery didn't actually make a copy of Celebration. There was nothing left behind. That's why I have this little gray box here. It was just an empty piece of paper. There was no copy. It was just a transfer of medium. And so Claude Théberge was not really happy with this because he sold his works in galleries for a lot of money on canvas. And he didn't want people to think that they were getting a Claude Théberge original, or even a reproduction, but a high-quality reproduction, for a lot less money than he actually sold it to them. And the Supreme Court of Canada held, well, what do you think? What do you think the Supreme Court of Canada held here? Was this a copy? No, they held it wasn't a copy. Well, that's one word for it. And that word comes up a lot in copyright law. This question, the Supreme Court of Canada held that this wasn't a copy because there was no copy made. It was a transfer of ink. But the really interesting thing is that the court divided. The court divided 4-3 on this decision. It was a heavily divisive decision from the court. Do you have a question? Size?
If you reproduce it in its actual size, it's to me like you're copying it. And if you're able to effectively remove the coloring and make it look a lot like the original.
Yeah, no, it was the same size. I wasn't able to fit it on this slide, but it actually is the same size as between the two. I mean, the court point in this case was that the court said he hadn't copied the work, that the gallery hadn't copied the work. There was still one work. It had just been transferred from a poster backing to a canvas backing. A lot of people have said that this case was decided incorrectly. So it's valid to disagree. I want you to close your eyes. They're not already closed. I want you to close your eyes and tell me if you think these two songs are similar.
She left with all of the clothes in yard.
So, yes, no? No? We didn't get to the core part of the song. They have the same words, still believe in love. This is a case that was before the Quebec Superior Court between Michel Pagliaro and Jim Zeller, and Jack Soul, or Hayden Neal, an R&B singer from Toronto. And the question was, were these two songs sufficiently similar? Did Jack Soul copy Pagliaro and Zeller's earlier piece? We don't have a judgment on this case. But the interesting thing about this case was the two songs had the same name, so they were both called Still Believe in Love. And experts actually divided on the question of whether they were very similar. And in some cases thought that Jack Soul had in fact copied Pagliaro and Zeller's song. And while you may agree or disagree, the real issue in this case is that there are a lot of things currently being produced in society as creative works that are in fact very similar. You know, Avril Lavigne, hey, hey, you, want to have my boyfriend or something? It's very standard lines. A lot of people would argue that music these days has actually become a bit generic, that maybe there are only 5 notes, 5 chords. This is another example. This goes to the idea that maybe a lot of creative works are actually just minor improvements on what already exists in the public domain. I don't know if any of you had the chance to go to the Disney exhibit when it came to Montreal last year. And it compared Walt Disney's works with works that existed in the public domain. This is Beatrix Potter's, what is it? I have the list. Mice Sewing Mayor's Coat, made in 1902, and that's the scene from Cinderella. The basic premise was that a lot of Disney's works actually drew on images from the public domain, and so the interesting thing is that Mickey Mouse is one of the most heavily litigated and protected mice in the world. Well, he is the most protected mouse in the world. He's covered by copyright and trademark rights, and some have argued even that US copyright term ages with Mickey Mouse. So every time Mickey Mouse threatens to liberate himself from copyright, he in fact is, again, covered by more copyright protection. And so the argument here is that a lot of works, we're talking about what a copy is. Well, is this a copy? Or is this an adaptation? Is it an independent work? And how much can we say we're being inspired by what already exists and what doesn't? Okay, so I'm going to ask you to, this is a standard radio show technique. I'm going to ask you if you can tell me if you recognize this. Do you know what that was? Yes. Yeah, Eleanor Rigby? Yeah, you were here? Okay, from the Beatles. Let's.
Hey!
Yeah, just the Beatles, I figured out. Let it be, yeah. So part of the problem in copyright laws, and when you're deciding whether something's a copy or not, you look both to the quantity and the quality. And some works are immediately identifiable. I only played you less than a second of each of those works, but they were immediately identifiable. And so if you were trying to judge whether something's a copy and it's immediately identifiable, you're much more likely to find it a copy than another work that's more generic. And that's the problem with copyright law, particularly in the music industry, and particularly surrounding these practices of sampling that have been so controversial of late. In fact, the US law says any sampling of another song is illegal, in part for this problem that parts of songs are incredibly identifiable. In Canada, we have Section 80, sub 1 of the Copyright Act, which is called the so-called private copying exemption. So it allows you, carves out a space in copyright law where you're allowed to copy musical works from one medium to another. So in fact, you could copy music from a CD onto your iPod without without violating anyone's copyrights. But that's not the case normally under copyright law. Copyright also encompasses rights that aren't purely economic. So the rights that I've been talking to you about up to now have been economic rights. But copyright also covers things called moral rights. Moral rights protect a creator's right to both be known as the author, but also to the integrity of their work. These are called the rights of attribution and integrity. And moral rights are an example of the way that copyright law in Canada has been influenced by the French or continental tradition. The most famous case in Canada about moral rights was Snow in the Eaton Centre. I don't know if you've been to the Eaton Centre. Michael Snow, the famous sculptor and all-around artist, created these Canada geese that fly over the Eaton Centre in Toronto. And in 1982, the Eaton Centre added bows to them at Christmas. This took a bit of time. I don't actually have a picture of what the geese looked like with bows, but I assume they looked something like this. And the question was, did adding bows to the geese infringe Michael Snow's right of integrity? So was this somehow harmful to his reputation? Was it a distortion or mutilation of his work? It could just be because my representation is so bad. But yes, you are right. The court, in fact, did find that the bows on the geese damaged his reputation, because people might think that he'd actually either designed the geese that way or that he'd somehow sanctioned this, and he didn't think it looked very nice. So not only can authors prevent their works from being copied, but they can also prevent their works from being used in association with causes that they might not agree with. For example, if you write a song and it's being used for a hate-based organization, for example, you can object to that kind of treatment of your work. So far we've looked at the kind of rights, what is covered by copyright, then what constitutes a copy. We've seen that there are a number of acts that constitute copies of works. We've also heard that, that moral rights are protected. So not only do we protect economic rights, but we also protect something about an author's right, something about their link to the work, their right of integrity, to the integrity of their work, and to be known as the author of that particular work. So we've talked a lot about the rights that creators have, but the question then becomes, well, what rights do we as users have? Because in every copyright interaction, there's both a user and a creator. We've all used copyright, and we've all created copyright at some stage of our life, and so we're locked in this ever-widening circle where the works we produce then become someone else's input to another creative work, and so on and so forth. And part of the magic of copyright law is about balancing the rights of users and the rights of creators, to make sure that users aren't unduly shut out of using creative works, but that creators are adequately compensated or protected for creating certain works. And the idea behind that is that once creators are adequately protected, they produce the kind of works that we as a society wish to encourage, the kind of works that might not be creative, but require some level of skill and judgment, and that aren't merely hard work. So, one of the basic ideas then is that, as I've said, most works actually come from some sort of public domain, and this is one of my favorite demonstrations of this. If I have seen further, it is by standing on the shoulders of giants, said Sir Isaac Newton in a letter to Robert Hooke in 1676. And then George Herbert said in 1651, a dwarf on a giant's shoulder sees farther of the two. Then the Spanish theologian Didacus Stella said, dwarfs on the shoulders of giants see further than the giants themselves in 1622, a few years before that. And then a year before that, Robert Burton said, in his anatomy, in his incredibly melancholic Anatomy of Melancholy, a dwarf standing on the shoulders of a giant may see farther than a giant himself. But that, in fact, came from John of Salisbury from 1159, a bishop and an academic who said, we are like dwarfs sitting on the shoulders of giants. We see more and things that are more distant than they did, not because our sight is superior, because we are taller than they, but because they raise us up and by their great stature add to ours. And this is a demonstration that as things evolve, as things enter the public domain, they evolve and they might become better. Maybe you think that Sir Isaac Newton's quotation was a bit pithier. It got to the substance of the matter a bit quicker than the original. And that's one of the ideas, is that our culture is constantly producing and reproducing works, and that access to these works and the right to reproduce and adapt them is important to us being able to create superior works in the future. And so how do we do that? Well, we've already seen we do that by ensuring that works fall into the public domain after a certain period of time. But then we also have these so-called fair dealing exceptions in the Canadian Act. And this brings us full circle back to CCH. We have fair dealing exceptions for a number of things. And I'd invite you, if you're interested, to look through the Act. I can't go through them all now. But there are a series of exceptions in the Copyright Act to what uses you can use. So you can, in fact, use works for the purposes of news reporting. So that's how, on The Daily Show, for example, they can show us clips, things that people said on Fox, for example. You can reproduce works for the purposes of criticism and review. So for example, if you're criticizing a poem, you could reproduce that poem and criticize it or review it in order to demonstrate your point, or if you're reviewing a video. And then you can also reproduce works for research and private study. And so the interesting thing that CCH said, well, what is research and private study? Is a lawyer who's reproducing a work for the purposes of advising a client, is that research and private study? No? That's interesting. I think it's interesting that the case went to judges, and the judges actually said, you know, that is research and private study doesn't have to be only for non-commercial purposes. So you can have research and private study that has, they sort of left it in the negative. It doesn't have to be not for commercial purposes. So research and private study for the purposes of figuring out what the law is so you can advise clients isn't necessarily outside the scope of research and private study for the purposes of the Act. But the court also said something really important in CCH, and it articulated this as the concept of user rights. And this was the first time that we've ever seen anything that looks like this in Canadian copyright law. And the implications of the decision are unclear because we're not actually sure what it means now to have users' rights. And this is how our law is actually becoming much closer to US law. The US has this fair use exceptions. It has a much broader right of parity. We actually don't really have a parity right, for example, in Canada. It's kind of interesting. We, in fact, have a much more limited set of exceptions to copyright. But the Supreme Court of Canada in 2004 said, no, in fact, copyright exists in this cycle of creation. So the works that you create then become the inputs to someone else's creative process. And users, in fact, have broad rights. And those rights are part of the Copyright Act. And the Act should be interpreted as if you have both creators and users creating works. And so users' rights will be interpreted much more broadly. And I won't go into the details of the users' rights test, but it does involve looking at the purpose of the work, the market for the work, the nature of the work, and a whole series of other factors, and balancing those in a rich sort of factual determination. So it takes us out of the listed exceptions and into a much broader determination of whether someone is in fact using a work in a way that might violate copyright, but they're allowed to because it's a species of fair dealing. So that concludes my talk. I hope you can think about how these principles around copyright, around originality, around what constitutes a copy, around when a work enters the public domain and then becomes freely usable, and then the kind of exceptions that you can use to actually to justify your use of a creative work in a way that might actually otherwise infringe copyright can in fact inform your passage through this world. Thank you.
If I take pictures or images from the internet to prepare slides for teaching, am I breaking copyright?
Well, you've seen I did that quite liberally.
You're not the only one in me.
Well, it's important to think about the exceptions. I get this question a lot. One of the really important things to do is to understand that the Copyright Act does, if there's a picture on the internet, presumptively it's going to be covered by copyright. As we discussed, so long as it passes the bare requirements of skill and judgment, it's going to be copyrighted, even if it's available on the internet with no other indication of its copyright terms. So you have to assume, if there's nothing else to sort of guide your discretion, that it is covered by copyright. And if it's covered by copyright, you have to assume that that using it might constitute an infringement. Now, if you can apply any of these criteria, news reporting, criticism, review, research, and private study, then perhaps it would be okay. And there are also a series of educational exceptions in the Copyright Act that you can also refer to. And those actually apply to copyrighted works used within institutions and might apply to your work. There's also a possibility that that work, when available on the internet, might be licensed to something like Creative Commons. You might be familiar with Creative Commons licenses or GNU free documentation licenses. And these are licenses that allow users to specify that they'd like to share their works as opposed to strictly enforce their copyrights. And so if you check those works, if you check that photograph, for example, if you go to Flickr, a number of pictures on Flickr.com, which is a popular photo sharing site, are actually licensed to Creative Commons. And Creative Commons licenses mean that you're actually allowed to use those works so long as you use them either for non-commercial purposes, depending on what the license says. So it's really important to consider what the terms that work is being made available to you are. And if you also access it on a site where the creator has suggested somehow that they don't mind you using their picture, then that's also good. And the final thing you should remember to do is that if you use someone's work off the internet, for example, and you think that they wouldn't mind and you're exercising one of your fair dealing exceptions or the concept of user rights, it's important for you to attribute them, at least to name them as the source of that work. Most people don't object to their works being used, so long as they're attributed as the author.
Is Canadian copyright law expected to become more restrictive or less restrictive?
Bill C-61, the legislation that was tabled in the sort of end days of the last Harper government, would have probably made Canadian copyright law more restrictive. Canada is considered a bit of a copyright outlaw because we haven't implemented a variety of treaties created by the World Intellectual Property Organization. The idea behind these treaties is to protect certain rights of performers and also to regulate anti-circumvention measures. So much of music, much of copyright today isn't actually enforced in law, it's actually enforced by copy restrictions. So maybe you've downloaded a file and you can't copy it onto another medium. The computer gives you a message that says you can't do this, or the file expires in a certain number of days. Those are called technological protection measures. And they're a way that copyright holders are in fact controlling the use of copyrighted works, not by relying on the sort of traditional legal mechanisms, but just relying on technological measures. And so when you've bought that piece of music, for example, you've agreed to that technological protection measure. So I don't know. The legislation fell. We have a new Minister of Industry who's going to be responsible for drafting the new copyright legislation. Chances are our legislation might become more strict, but it seems also that practice is becoming more liberal. So there might be an increasing divide between the law in the books and the law in practice. And I think that's maybe where we're going with the copyright legislation in Canada.